Hi guys, today our topic is about Indian Contract Act 1872. Under the Indian Contract Act 1872, it is divided into Law of Contracts 1 and Law of Contracts 2. Law of Contracts deals with the general principles of contracts and Law of Contracts 2 deals with the special contracts. So today our topic is about bailment and pledge, which deals with the sections 148 to 181. Bailment is derived from the French word bailor, which means to deliver. Under section 148 of Indian Contract Act 1872, bailment is the delivery of goods by one person to another for some purpose upon a contract subject to certain terms and conditions for return or disposal as directed after the purpose is accomplished or completed. And the person who delivers goods is called bailor. The person to whom the goods are delivered is called bailee. For example, if A delivers a piece of cloth to B, a tailor, for stitching a shirt, the contract between A and B is called bailment, and in this example A is called bailor and B is called bailee. Next, essentials or conditions of bailment. First one, delivery of goods. Second one, contract. Third one, return or disposal of goods. So coming to the point of delivery of goods. For the essentials of bailment, the goods must be delivered from one person, which means bailor, to the another person, that is bailee. Delivery means transfer of possession of the goods from one person to another. The delivery of goods to the bailee may be made by doing anything which has the effect of putting the goods in the possession of the intended bailee or his authorized agent. Next, contract. There can be no bailment without a contract. Bailment is a contract, and the essentials of contract under section 10 of Indian Contract Act 1872 must be fulfilled. That is, free consent, competency of parties, lawful object, etc. are to be satisfied to constitute a bailment. So, without a contract or without a bailment, there is no a contract. So, to constitute a contract, there must be essential elements which are to be fulfilled under section 10 of the Indian Contract Act 1872. Next, return or disposal of goods. In bailment, the goods are delivered for a specific purpose, example stitching or repair, etc. After the purpose is accomplished or finished, the goods may be returned to the bailee in the same or altered condition or may be disposed as directed by the bailor. Next, coming to the topic of kinds of bailment. Bailment may be classified under the following heads, kinds. First one, bailment for the benefit of bailor. Where a bailor delivers his goods to a bailee, normally for a safe custody without any reward, it is called bailment for the benefit of bailor. Next one, bailment for the benefit of bailee. If the bailor delivers goods to a bailee without any hire for his use, it is bailment for the benefit of bailee. Next one, bailment for the benefit of both bailor and bailee. If the goods are delivered for consideration, both bailor and bailee derive benefit and hence it is called bailment for the benefit of both bailor and bailee. Gratuitous bailment. A bailment made without any consideration for the benefit of the bailor or for the benefit of the bailee is called gratuitous bailment. Non-gratuitous bailment. It is a bailment for reward. It is for the benefit of both bailor and bailee. Next, rights and duties of bailor and bailee. Rights and duties are corresponding to each other and are correlative. Therefore, the rights of the bailor are the duties of the bailee, and vice versa. Now, duties of bailor. To disclose known facts of the goods bailed under section 150. Bailor has a duty to inform the bailee if there is any defaults or defects of the goods which are bailed. Otherwise, the bailor is liable. For example, A lends his defective car to B. A knows that defection but does not disclose the same to B. So, A is liable for the loss suffered by B. Next, to bear the extraordinary expenses under section 158. The bailor has a duty to meet the extraordinary expenses incurred by the bailee. He is also responsible for the ordinary and reasonable expenses. Next, to indemnify the loss under section 159. Indemnity means promise to make good the loss. Bailor has a duty to indemnify the loss suffered by the bailee under the contract between them. Next, to take back the goods bail under section 161. In bailment, the goods are delivered for a specific purpose. After the purpose is completed, the goods may be returned to the bailor. Then he has a duty to take back them. Next, rights of bailor. Enforcement of rights. The bailor can sue the bailee to enforce his rights or the duties and liabilities of the bailee. Next, to avoid the contract. The bailor has a right to avoid or terminate the contract if bailee acts contrary to the terms and conditions of the contract. Next, right to claim increase in profit. If there is any increase in the profit of his goods with the bailee, he can claim such extra profit also. Right against third party or subrogation. Subrogation means transfer of right to sue from one person to another person. If the third party causes loss to the goods in bailee's possession, bailor can sue the third party. In subrogation, the bailee's right to sue the third party gets transferred or subrogated to the bailee. In other words, the bailor enters into the shoes of the bailee and acquires the right to sue the third party. Next, duties of bailee. To take care of the goods which are bailed under section 151. A duty on bailee as a reasonable and prudent man to take much care of the goods which are bailed. The burden of proof that he had taken a reasonable care and had not acted negligently lies on the bailee only. Next, unauthorized use under section 154. The bailee must not misuse or make unauthorized use of the goods which are bailed. If he do so, he is liable to pay compensation to the bailor. Next, to act in conformity with terms and conditions under section 153. The bailee must act in compliance with the terms and conditions of the contract only. If he does not do so, he is liable for that. Next, not to mix goods which are bailed under section 155. The bailee should not mix the goods bailed with his own goods without the consent of the bailor. If the goods are mixed, they may or may not be separable. If separable, the cost of separation should be borne by the bailee only. If the goods mixed are inseparable, bailee has to bear the loss. So, the bailee has not to mix the goods with his own goods. Next, to return the goods under section 160. In bailment, the goods are delivered for a specific purpose. After the purpose is completed, the bailee has a duty to return the goods to the bailor. Next, rights of bailee. Right to recover expenses under section 158. The bailee has a right to recover all the expenses incurred and remuneration for the services rendered by him under the contract between the bailor and bailee. Next, right to recover compensation under section 164. The bailee is entitled to recover compensation from the bailor for the loss sustained by him. Next, right of lien under section 171 and 172. The term lien means right to retain the goods till the dues are cleared. The lien is of two types, particular lien, general lien. In particular lien, gives the right to retain possession only of goods in respect of which the changes or dues have arisen. In general lien, It is one which gives right to retain possession until the whole balance of the account is paid. It extends not only towards the goods pledged as security but also in respect of others. Right against third party or subrogation under section 118. If a third person deprived bailee from possession or enjoyment of the goods bail, he can sue such third party. This right to sue third party is also available to the bailor under the right of subrogation or doctrine of subrogation. Next, finder of lost goods, section 71, 168 and 169. Who is a finder of lost goods? When a person finds some goods belonging to another person, he is called finder of lost goods. He has a right or duty to return them to the real owner. If he does not to do so or misappropriates the goods, he is subject to civil and criminal liability also. The finder of lost goods has to make necessary efforts to find out the real owner. He can dispose of the goods if they are in perishable nature and to pay the amount to the real owner after detecting the lawful charges. Next, rights of finder of lost goods. Right to retain. The finder of lost goods has a right to retain the possession of the goods until the true owner is found. He has a right to take action against any other person who deprives him of the possession of the goods. Next, right of lien, section 168. Right of lien to retain the goods against the true owner until he receives such compensation where the owner has offered a specific reward. He may sue for such reward and may retain the goods until he receives it. Next, right to sell under section 169. The finder of lost goods has a right to sell if the true owner is not found despite making all efforts or the true owner refuses to pay the lawful charges, if the thing is in danger of perishing or of losing the greater part of its value, or when the lawful charges of the finder in respect of the thing found amount to 2/3 of its value. This is the topic about bailment. Thanks for watching my video, and next video is about the topic pledge. Stay home, stay healthy.